The Commission is required to provide sufficient reasoning for its decisions and to address relevant arguments put forward by the parent company in relation to the interaction between itself and the parent company, such as no interlocking board membership, subsidiaries chairman and chief executive having considerable autonomy, and evidence was produced to back that up, having its own sales, marketing departments, etc., the fact that it had the sole responsibility for pricing strategy. I mean, that's not to say that the arguments would have rebutted the presumption, but the Commission only paid lip service, and therefore they didn't adhere to all the procedural requirements they were supposed to. In Gleiche Gross, once again procedural grounds came to the rescue of the parent company, as the Commission failed to specify whether the individuals who took part in cartel meetings belonged to the parent or the subsidiary, and furthermore the Commission failed to provide adequate reasons. In Elf Aquitaine, which was 98% ownership of Alfima, the subsidiary, the Commission once again failed to state adequate reasons and address the arguments of the parent company. It has been claimed that these decisions are derogations from AXO. These decisions are derogations. However, these are procedural requirements, and while not unimportant, it does not alter the fact that there is the 100%, when there is 100% ownership, there is a rebuttable presumption that the parent company has exercised decisive influence, and if it fails to rebut that presumption, then the anti-competitive conduct will be imputed to the parent company. If we look at another case where it was less than 100%, Gotteland and Stichting Administratiekantoor voor Deeltje, the presumption was actually rebutted, the presumption of decisive influence, because the first meeting of the Board of Directors of Deeltje took place 2 years after the end of the infringement, and the only activity of the parent company to exercise the rights was voting at the annual general meeting. That was the only time it could influence the policy of the subsidiary, and no such meetings were held during the relevant period of the infringement. If we go through a few other issues, whether a presumption should exist, Advocate General Cocotte believed that the idea of presumption should exist was justified because it created legal certainty. But why is there a presumption? It's because of the common practice, and I believe that this is correct, because if the court is slow by sticking to purely legal means, if it's slow to recognize the entirety of workings which take place inside a business, then it provides a sizable loophole for a parent company to complain or to claim successfully that they had nothing to do with the anti-competitive practice of the subsidiary. However, if you have a large ownership stake in a company, and especially if you have 100%, it's very unlikely that the businesses will turn the other cheek and ignore completely the activities of the subsidiary. And especially where subsidiaries having to take a great risk, it knows it could incur a great fine, so it is likely that it will seek the approval, tacit or otherwise, of the parent company. That fines have been ever increased gives rise to the dissuasive nature of the fines, although this has not entirely worked because there are still being fines imposed of ever higher amounts, not necessarily because of the trend towards that, but because companies are still committing are still guilty of anti-competitive behavior on the market. However, one must be careful. In Worldwide Tobacco España, the Court of First Instance held that the objective to be pursued is to guarantee the effectiveness of the fine by adapting the amount with due consideration to the global resources of the parent company. However, if this is the only reason taken into account by the Commission and the Court, then it goes beyond the principle of proportionality and is deemed to be excessive. Finally, the European Court of Human Rights has been asked to rule on whether the principle confirmed in AXO runs contrary to the presumption of innocence from the right to a fair trial under Article 6 of the Convention. This will take years to go through the Strasbourg courts, owing to the slow nature of litigation in Strasbourg. However, in the General Court, in the case Elevators Escalators, decided Strasbourg jurisprudence itself, in order to maintain the presumptions of fact or of law can be made in the domain of criminal law without breaching convention rights, subject to reasonable limits and maintaining defence rights. This, of course, will become a much greater issue once the European Union, as expected, accedes to the European Convention of Human Rights. Thank you for listening.